the drag queens, so drag queen story hour. So initially I started having a discussion with two police officers, obviously it's all recorded. They were quite nice, quite forthcoming.
Individually,
Yeah,
individually talk to police, they're just like you and me.
well, they first started, they obviously they started with me, but automatically as soon as I started, you know, writing off a few things, they obviously you knew what you were talking about, and that was it. But the inspector that I met, he was slightly different. So he came up to us and he said,
That cop.
yeah, so the inspector came up to me at, this is in Tilehurst one, and he said to me, obviously he said to us that he was having a chat about four of us, and he said that, you know, if these guys keep on hurling abuse, etc., blah, blah. I said, no one's hurling abuse, mate. I said, all they're doing is saying, you know, why are you going to see a pedophile, which is legit, because there's evidence of the fact that an individual is a pedophile, and you're the ones who are protecting the pedophile. So then he said to me, obviously when I started challenging him, and I said to him, you know, he said to me they were going to disperse on Section 14 of the Public Order Act. And I said, and I said, what gives you lawful excuse to do so? And he goes to me, you know, he then said, have you been researching Google? That's what he said to me. I said, you've been at Google? I said, yes, mate, and Google's my friend. And I carried on talking. And then I said, I'll hold you personally accountable. No, actually, no. What I said, no, I actually used DuckDuckGo, but thanks for asking. And then I carried on and I quoted 2009 Ricey and then etc. And then all of a sudden, he had a discussion, ignored me, and then went around and made a personal phone call or whatever he was doing. So I said, I'd hold you individually accountable for trying to disperse this crowd unlawfully. We have every right to be here. I said, the bottom line is you're not doing your job, so we will stay here, and we will stay here, and we will act lawfully, and that was it.
Yeah, and this is basically why. Because you've got knowledge, that gives you the confidence, which gives you the courage to interact, to stand on your rights. Okay? And they're just not used to this. That's all. Okay?
I'd just like to interject
Yeah.
on that point that we were talking about. With regard to fracking, GMO, the right to protest in general. I mean, they've tried to restrict the right to protest.
Yeah, yesterday we were talking about
Yes.
injunction. No, when they were trying to, I don't know if you're aware, but basically in Blackpool they were trying to get the pig pen injunction thing.
Didn't work.
Didn't work, thanks to Joe Boyd.
Thank God.
And again, it gets worse than that, because basically, when at the hearing for the permanent injunction, basically. There were a few of these human rights organisations that were trying to, you know, stand up for your rights, nonsense. And Joe stood up, and his was the only thing which turned over that permanent injunction, stopped that going. One guy against all the legal professionals. Okay? One guy, you and me, that's how powerful we are. Okay, so basically, contempt of court, anything which prejudices any party. Therefore, any action from start to finish which may prejudice a party, raises a suspicion, okay, that there needs exploring and stopping. So the biggest thing, and all of these claims here stem out of one little thing. All right? There was a belief by a defendant who's present that the police were withholding some evidence. What happened was there was a phone which allegedly recorded everything walking in and walking out. And some policemen applied their mind to record certain parts of the video from the phone and enter that into evidence, but the phone wasn't entered into evidence. Does that not raise a suspicion in a criminal matter that's beyond reasonable doubt, the test, but just the sheer fact that somebody applied their mind to record the video and put that in? That alone should have ended this. And now there's over 60, how many claims, Gav? No, Gav, how many claims? 60 something? Okay. Which came out of that single incident.
I've got the same thing in mind.
And this is everywhere.
I'm still ain't got the phones back.
Huh?
I'm still ain't got the phones back.
And still haven't got the
Court
phones.
orders.
Yeah. Okay? So basically, that there sums up the rules of evidence. Okay? If there is any evidence that is needed by either party from the other party and is withheld, that is a contempt of court. Why? It creates bias and a suspicion of the miscarriage of justice. Simple as.
There has to be an intention to bias, doesn't there? When we
Yeah,
talked about it yesterday, it's got to be by intention.
but
deliberate.
if I ask,
Yeah.
okay, and you don't give, there's your
Yeah, yeah.
intention.
Yeah,
Yes, Nick?
Intentionally or knowingly on that one.
Yeah.
But I was just saying on a simple practical level, when you're recording with your phone, you can record directly to the cloud. Straight away.
Okay, now at this point here, there's somebody else that contacted me, and the 1st of May, they took the phones. Files were deleted between the 2nd and 7th of May. In June, a declaration was made that they couldn't get into the phones because they were key locked. And in August or September, they unlocked the phones. They had the phones. Their own evidence shows that their phones were tampered with, and they're still bringing this nonsense into court. You can't make this nonsense up.
Record it to the
All
cloud.
over the show, eh?
Record it to the cloud. It's there, it's evidence. The whole thing is there.
But again, that's a bit of a problem because it was live streamed but deleted, wasn't it, from the cloud, from Facebook or whatever it was. Anyway, but yeah.
No, not to Facebook. It wouldn't rely on Facebook.
Yeah.
It's
No,
dropped.
yeah. Okay, so the court can only reach its decision based upon the evidence before it.
Sorry, Mark.
Yeah.
I've got to say on that. There's a software called Restream where you can record. It's called RESTREAM. So you can stream live to several different outlets, to YouTube, Facebook.
What's it called?
Restream.
Can you spell it
Restream.
now?
RESTREAM. And I believe you can also record it to the cloud, so you've got your own record of it.
Brilliant. Okay, so it's all about evidence, end of. Evidence includes, but they try and avoid it, to be evidence of law as well. And we saw yesterday that the job of the court is an independent dispute resolution location. The first job is to determine the parties' respective duties, rights and obligations to one another. And then it must make a determination only based upon that evidence before it. Okay? So it's very, very clear, very, very simple what should be going on there. Okay? And everything is based on evidence. So, again, the Attorney General versus the Times, the case that we looked at yesterday, okay? Free from bias to any party, blah, 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 based upon those facts only that have been proved in evidence adduced before it. Okay? So, everything's about evidence. Now, the problem we've been having with holding people to account is, guess what? We've got crappy evidence. So that's what the Peacekeeper course tries to do, and what we'll be doing here, because you'll see, we're going to go and start to audit what's going on in the court. We are going to be creating a record. That's our evidence. And where they do not do their jobs properly, we then can bring a case to hold them to account. Okay? So evidence, without evidence, you can't proceed with anything. You will get nowhere. Okay? We've talked about judicial notice. So what is judicial notice? How did it come about? Basically, the first case that I helped somebody with CV was, what happened was, we went to the, okay, the way that it works in court, and we're going through this in a minute, basically, in effect, what happens is, the first stage is what's called pre-trial. Has everybody got what they want and need from one another? If that is, once that is settled, then it proceeds to trial. Okay? and we'll look at the details of it. But basically, we went to the hearing. It was in front of a magistrate's court for not filling in one of these passenger locator forms. And so we started off with the sort of arguments about it's got no legal authority and they're using the Public Health Act instead of the Coronavirus Act and all of this sort of stuff. The prosecutor was on a TV screen, and you could see, basically when we started, you could see, oh my God, another one of these. Okay? When we got more into the detail and we started quoting sections inside the acts and all of this, you could see like, and you could see his face, literally, you could see, oh shit. We didn't even finish, and the district judge turned around and said, right, heard enough. Clark, can you give me my next availability date? I want to hear this case. And he ordered that we submit our arguments within 28 days. And then the hearing was like 28 days or something later. When we got to the hearing, okay, now bear in mind what we've already talked about. Okay, so what happened was in the opening statement of the prosecution, the court can take. We asked the court to take judicial notice of the existence of coronavirus. Okay, that didn't click with me. Right. So basically, because I didn't know what judicial notice was, in the judgment, and our whole case was when we cross-examined the port officer, the customs officer, or whatever, you know, who gave it the fine or started the thing, and we asked him, what led you to the belief that you had lawfully excused to breach of peace regulations? So, for the regulations to have the effect of law, it needs to have legitimate aim. So, what led you to the belief that it exists? Oh, I don't know. So, the judge, so the next question then was, oh no, I don't know, I'm not an expert or scientist or whatever. What made you believe that it causes unique harm? Same answer. What led you to believe it's transmissible? Same answer. The judge then intervened and said that he can only answer questions that he is with his knowledge. So what you had here was the head manager of Dover Ports, immigration or whatever, saying, I don't know. So judicial notice is a really powerful tool, and again, when you look at the substance behind it, what you're trying to do is not waste the court's time by arguing that wheels around, that interchanges are either a roundabout, a stop street, or a give-way sign, or traffic lights, or a flyover. Okay? The obvious, things which are self-evident. That's the idea of judicial notice. Acts of Parliament, it's self-evident. They've been publicly noticed. They're publicly available. Most people know where to find them. They might not know what to do with them, okay? But it's there. So you're trying to avoid wasting court time by having somebody to prove grass is green or the sky is blue or black is white or whatever. So so with this, based upon what the judge decided, he decided to take judicial notice of the existence of CV. Was it right or was it wrong? If a manager has no evidence, what on earth makes the judge think that this is common knowledge? Okay? And the second thing is, where did this claim of common knowledge come from? Bloody TV, newspapers, all of this nonsense. That's all hearsay evidence. And one of the requirements is that something is either observable by observational experience, which CV isn't, and or is easily attributable to a reliable authoritative source. So show me the original science that claimed isolation and the existence of this thing, and transmissibility. And you have the right to appeal judicial notice, but at the time I had no idea.
So Mark, were they saying that they gave judicial notice?
And the courts accepted it.
that
He who
coronavirus
asked
exists?
yes.
They gave judicial notice that the coronavirus exists.
And everybody knows it. So what should have happened for what we've already said so far? Okay, I'm the prosecution.
Rebut.
What should have happened was, I'm asking the court to take judicial notice. Mr. Litigant and person, you understand this is a technical legalese term that we use, and this is what it means. Had he done that, I would have said, no, fucking object. Okay? Therefore, the officer of the court, the prosecutor, was in breach of his obligations to the court. The second thing is, he is trained and experienced and should know that hearsay evidence of what you see on TV or read in the newspapers is not admissible evidence, so he should not even have asked the court to take judicial notice. Okay? And thirdly, what he should have done is, given the court guidance, it was the magistrate's court. It's the court, the fiction of law, that grants or makes the orders and makes the determination through its agents, the judge. He should have given guidance to the court when it can or can't use judicial notice. So that's what should have happened. But I was ignorant at the time. I didn't know what judicial notice. I went straight home and thought, what's this judicial notice nonsense? Okay, and then I went more in. It's basically a specialised area of the rules of evidence. It's not common knowledge. And the officer of the court failed in their obligation to do it.
Have you challenged this? Have you appealed it?
No, she's got money, and basically what we'll do is the people that have something to lose, be careful with taking to appeals. Okay. But also that was the first case. What I know now, going back, was too late. Now, basically, hopefully it becomes self-evident now with what we've said, with the knowledge that we've got, that it's perverse or an error of law to make a finding of fact for which there is no evidential foundation. Okay? Everything is about logic and rationality once it's beyond the survival instinct. Law, in the context of what we're talking, is about rationality. So,
Divisional court, is that county court level or higher court?
oh, I don't know. The divisional will be the region, so to speak.
County.
So, like for instance, Liverpool Magistrates Court covers 4 magistrates' courts. So, but the region includes basically the whole of the northwest.
It's only binding on lower courts, isn't it?
The court structure at that time, okay, this will basically be like an appeal court for that region, whereas now there's one appeal court for the whole country. So you've got to go through the structure. However, again, remember, equity prevails over the common law. That is perfectly equitable. Therefore, it's binding on every court, even if this decision was made at a lower court, because the rules of equity apply with every court. And that is very equitable. So basically they call it, you can appeal on 2 grounds. One's an error of law and the other is actually perversity. It's perverse how they managed to reach that conclusion based upon the okay? Right. Basically, if any evidence is denied, guess what? Contempt of court. So, disclosure is so important, and if you don't ask, you will not get.
Whatever in your case, in terms of where you guys said that he was obligated to rule X, Y, and Z. If that is contempt, are you holding that individual accountable as well, or?
They're all in appeal. Okay, right. The Finlay Coffee case and Sue's going more than 5 miles. All right. I tried sort of like all the different forms of appeal, and they refused the judicial review.
Yeah.
However, because we've got the transcript from the Crown Court that it acted unlawfully, okay, and I just literally, I hit a wall and I've not found the way around. I know I've got a way around. So what is the way around? Is it to carry on trying to fight through their system, or do we try something new? So guess what we've got? What we're doing is, and with the council tax stuff throughout the country, where the courts have been biased, unlawful administrative courts, I've got to sit down and do a format for Section 142, which we'll talk about just now, and appeal that, and take that evidence, together with the 2 judgments from the Crown Court, that they're not courts of law, but administrative courts to implement the will of Parliament, and to build, that's all becoming part of the evidence which will go to the Lord Chancellor to say, hey mate, you're in breach of contract. Your job is to ensure that the courts are independent, unbiased, and here's all my evidence, including transcripts from you guys, to say that you guys are operating a criminal fraudulent scam. You've got 28 days to come back with a proposal. How are you going to stop this nonsense? So that's the way around. If he does not act upon that, then we will start to take prosecutions. But it's a matter of time. I just haven't got enough time for these sorts of things.
So, Mark,
Yeah,
in a situation where you've applied the transcript,
yeah.
the transcript, you're ensuring that you get the full transcript.
Well, it depends, okay? It's not cheap,
Yeah.
but I've got the full transcript of the judgment.
So
You can get certain sections,
yeah.
okay?
I wanted the full transcript, and the transcript agency said to me that the judge has the option to amend it.
No, he doesn't. He does not, because the transcript is a public record.
Right. So I
If the
said, what's
judge
the point?
amends it, that is tampering with the public record. Serious nonsense like that. The judge must approve it.
Yeah.
He has no right to amend it. Okay? So there's a difference. But again, you know, that point of law may be misunderstood by the person on the other side of the phone or other side of the email. Okay? But a court of record is word for word what went on. It's not, you know, what you want in there or what you want in there or what you want in there. Okay? Which is why, like I was saying there, the court of record, we need to go back to them now and zoom in on that and say exactly what you need.
Yeah.
Okay? But no, a judge has no right to amend the transcript, because that is tampering with public record. Okay, so I want to just go back to equity again to show you, and what I'm trying to really drive across is the system actually is very good. And we are the problem, because we are not holding them to account to do their jobs. So the first thing is court sentencing must be equitable. I spoke yesterday about the Sentencing Act 2020. Guess what? This is after this massive conspiracy to control us all and to manipulate us and all of this stuff. 2020, very new, okay? And in that, it says, firstly, no fine can be higher than that authorised by Parliament assembled. So that's one constraint on what they can do. So what they've been doing is saying if you appeal this, the fine's going to get bigger.
And your sentence will get longer.
And your sentence will get longer. They have no authority
But they're
to
doing
go
that.
beyond it, but they're doing it. Okay?
But it's in there, it's on their actual documents, and it's like, you know, when you appeal, I mean, I'm talking about
It's on their
Victoria,
document.
it said if you appeal,
This is primary legislation. Anything down there must comply with this. And we've used this effectively. We've knocked off over £20,000 of fines using this. Basically, the Finlay Coffee case, they were fined initially 30,000, and what they did was, because of this, what we presented, they reduced it to 15,000 and put all the costs onto the company, not onto the individuals, on the directors. It still is not acceptable. But what they try and do, okay, and they'll always ask you, you know, and so with Debbie's case, the potential fine was, I don't know, something like £2,000, and we used this and said, no, you can only do this, and Debbie, and through this, basically, literally, what the magistrate was telling him was, listen, Debbie, what we're going to do is just, it's going to total this £200, but we'll explain the technicalities to them, how they've got to break it down into fine, costs, and victim surcharge. And what they're doing with this stuff is saying, hey Dwayne, look, we're really nice, we could have fined you £2,000, but we're only going to fine you £200. Are you okay with that? Guess what you're doing there? Joinder, consent, contract. They always want the disputing parties to consent and agree. Why? Because then they can't do a whole lot personally. Because you guys are making a decision, you guys can consent to it, right? Okay? So with the bundle with Calvin for next week, okay, the court said, I want a joint agreed bundle. Why? Because then both parties have agreed as to what the evidence is. They can't sit and argue in the court as to whether they've got or haven't got the evidence from one another. Consent, agreement. Okay? So basically, the other side wanted to put in and suggested what goes in. Calvin objected and said, no, I also want this in. The other one said no. I said, fine. Okay, you put in your bundle, we put in our bundle. What's the problem? Okay? But
So,
be careful, because that's where they try and get agreement.
so Mark, like in my case, they said to me, if I plead guilty, they'll give me a 33% discount.
Oh, really?
Yeah.
I feel. Yeah. Okay. And so what they're saying is,
Yeah.
oh yeah, I'll take 33% discount, please. Yeah, sign it. Contract. Okay. But when you understand this, okay, you'll see how equitable it is. So basically, they can't fine more than what is specified, but they can fine less. Okay? And they can't fine more than you can afford. So if you only got £5, okay, and somebody's told me, and I've got to verify this, okay, basically I can't remember what the court said with the fine, and they just turned around and said, no, I've only got £10, and they took £10. That was it, and no. But the legislation is clear. You must inquire into the individual's financial circumstances, and you cannot fine more than the person can afford. So basically the test is, cannot order a fine or surcharge if the individual has insufficient means to pay both. So it comes down to the word means. What does that mean? Well, I've only got £10, mate. But if they turn around and say, but you've got every week £10. No, that's potential. This is all I got.
what about property and stuff?
Property, again, okay, is something that comes into means. Okay?
If they sent the forms out and someone hasn't sent them back, they've inquired, haven't they?
No, let's go back quickly. Actually, we haven't really talked about the three notices, okay, and how this works, and links back to the breach of peace. So what happens? He who stands on their beliefs, okay, does what they want, until somebody challenges that belief. And the way we challenge a belief is, prove your actions are lawful. Okay? All I need to challenge, to breach their peace, is a suspicion or reasonable doubt with evidence. Okay, I can't just say, "Oi, prove to me it's lawful." I need to evidence my belief as to why it may not be lawful. Why am I trying to breach your peace, asking you to prove your claim? So, go back to the masking issue. What happens is, human nature, okay, we all start to research stuff and our egos grow and grow as we've got all this knowledge. So, somebody says, "Oi, you want to come shopping, you mate, put a mask on." How we choose to react determines what happens in law. I can turn around and say, "Look, I've done all this research, and look here, mate." No, you don't. Well, what's happened in law? I have become the claimant now. I've made a claim by saying, "Look how clever I am, and here's all the evidence that you're wrong." That's ego. Okay? Quite keep it simple. He who claims must prove. Can you please show me the evidence that has led you to the belief you can lawfully breach my peace by asking me to wear them? You leave the burden of proof with them. You always ask. Show me the evidence. Okay? So basically, they believed they had the right, and it's how we challenged it, or didn't challenge it. So the way that we do this is the process of 3 notices. So what we do is the first notice, we put them the facts, which gives us lawful excuse to breach their peace. So they've asked us to comply with their command, and we turn around and say, "Please prove my obligation and your right, and here's why I believe that you're wrong, and that gives me the right to breach your peace." What have I done? I've put them with the knowledge that their believed right is in dispute. That creates what's called an equitable estoppel. Under the rules of equity, you have your belief, you've now been challenged, therefore you must cease and desist. You are stopped from continuing with your belief. Therefore, when you put in your first notice, what should happen is, I believe your continued action is breaching the peace, and therefore you need to cease your belief and prove your belief and desist until that's proven before you can continue. If they choose not to, I send my first witness, my second notice. I've given you the opportunity to provide remedy. You failed to do so. Therefore, you've acted in dishonour, bad faith, and with unclean hands. And also, this is my first witness, I put you with the facts. If they still continue, I do the second witness, and my second witness says, "Hey mate, you're still dishonouring me." And this is my second witness that I put you with the facts. Okay? So, what I've done there is, I've got 2 witnesses of having put you with the facts. From the mouths of 2 witnesses, may the truth be established. Also, the courts only look at 2 things: the intent, the state of mind. So, yes, I've proven I've put you with the facts, and I've proven you've continued. So therefore, your continuance, you could have turned around at the beginning and said, "Shit, you're right, sorry, honest mistake. End of. I see some stop doing that behaviour." But should I continue once I'm with the knowledge, I'm now doing it with the knowledge of the dispute, and therefore I can no longer claim honest mistake of. If you continue with the knowledge, you now are acting negligently.
No, reckless.
No, not yet.
Negligent.
Not yet, Nick. The second witness, if you continue, you are acting